A very good morning to all. I, Dr. Rashima Prabhakar, Assistant Professor from Khalsa College of Law, Amritsar, is here to discuss about elements and stages of crime. The Indian Penal Code is one of the criminal laws of the country. It was drafted by Lord Macaulay and it came into operation on 1st January 1862. It has 511 sections in total. The Indian Penal Code is a document that lays down in detail the offences and the punishments to which the person can be held liable if he commits any of these prohibited acts. It is applicable equally to everyone, whether it is an Indian citizen or a person of Indian origin. But yes, the persons who are immune by the Article 361 of Indian Constitution, like the President, Governor, diplomats, they are also immune from the applicability of Indian Penal Code. And moreover, the military offences like desertion and mutiny committed by the forces, armed forces, that is also not covered under Indian Penal Code. Now, what is crime? The word crime has not been defined under Indian Penal Code. In a common sense, it is often defined as an act or an omission that is baneful to the society at large. The concept of crime is relative. Different societies at different point of time have considered different acts as crime, depending upon their different localities and circumstances. History is replete with such examples. The ideals, they may change. Standard of public morality may change. Along with it, changes the acknowledgement of crime by the legislature within the ambit of penal code. The recognition of crime depends upon the public opinion of a given society at a given time. And there is no rigid or absolute criteria to determine it. It is rightly said that concept of crime is neither static nor can be taken in absolute terms. There is no thing as crime in se or crime by itself. It is necessary that same should have been punishable by the legislature. So in the same line, crime is often taken as any act that is made punishable by the legislature, forbidden by the statute, and is injurious to the society, to the public welfare. Now coming on to the elements of crime. Crime has four main elements. Number 1, human being. Number 2, mens rea. Number 3, actus reus. And number 4, injury. Number 1, human being. For any act to be made punishable by the penal code must have been done by the human being. Second is mens rea. It is the mental element or it is the evil intention. The act which is done by the human being must have been done with the requisite mental element. He should have the intention to do that act, the mala fide intention. Actus non facit reum, nisi mensit rea, is the Latin maxim in the criminal law, which says an act cannot make a man guilty unless his intentions were so. This shows that intention is an important ingredient of an offence under Indian Penal Code. And the legislature has also, while drafting this Indian Penal Code, has taken due care by denoting the state of mental care as required in every offence by the use of the terms like negligently, rashly, voluntarily, intention, knowledge, etc. The third element of crime is actus reus. It is the act done. It is basically the result of human conduct that law seeks to prevent. As referred in section 32 of Indian Penal Code 1860, words referring to act done extends to include illegal omissions unless contrary appears from the context. Fourth and the last element of crime is injury. As defined under section 44 of Indian Penal Code 1860, injury means any harm whatsoever illegally caused to the person in body, in mind, property, or reputation. So, these were the 4 elements of crime. But sometimes the person is charged for the punishment for an offense even without the requisite mens rea. There are certain exceptions to the rule of mens rea under Indian Penal Code. First is those acts that are criminal in form but summary mode of enforcing a civil right. Second, acts not criminal in form but are prohibited under public interest by a penalty. Third, public nuisance. And fourth is the strict liability offences, as for example bigamy or waging war against the government of India. Apart from that, sometimes the person is held liable for an offence even if no injury has been caused, as in the case of inchoate crimes. Now moving on to stages of crime. Crime is usually committed in 2 ways. Either after a premeditation with planning, the other way is without premeditation at the spur of moment. So the crimes which are committed after premediation usually have 4 stages. 1. Intention. 2. Preparation. 3rd attempt, and 4th accomplishment. Intention is the first stage of crime. It is basically the mental stage. It is the stage when the doer perceives an idea of committing an offense. As discussed earlier, mental element is very important in IPC. But yes, as discussed earlier, there are certain exceptions also to this very rule. Second is preparation. Preparation is when a person has conceived an idea of committing a crime. He moves further preparing for the same. So preparation is the means, arranging the means and the manner for the accomplishment of that very idea, that which has been perceived by the doer. Preparation to wage war, preparation to commit dacoity are some of the offences punishable at this stage. The third stage is attempt. Once the preparations are made, attempt is the direct movement towards the accomplishment. The Indian Penal Code deals with attempt in 4 different ways. Attempt to commit suicide is punishable under section 309 Indian Penal Code. Suicide is the offence that is punishable, that can be punishable at an attempt stage, and in no way can be punishable once it is completed. Second, attempt and commission, they are covered under same section. Same punishments are awarded for same, for both the commission and the attempt. For example, attempt to wage war against the government of India and waging war against government of India, they are covered in the very same section. Third, attempt and its commission are dealt under separate sections and separate punishments are provided for the same. For instance, in the case of murder, commission of murder is dealt under section 302, whereas its attempt is dealt under 307. And fourth, in all other cases where no provision has been made for the attempt, section 511 punishes those very attempts. It prescribes 1/2 of the longest term of imprisonment provided for the offence to be the punishment for its attempt. Now, the fourth and the final stage of crime is accomplishment. If the doer succeeds in his attempt, he will be punished for the accomplishment or the completed offence. And if he fails in his attempt, he will be punished for the attempt of that offence. That's all for today. Thank you so much.